My names are Danstan Omari, an advocate of the High Court of Kenya and an expert both in criminal and family law. Today we are looking at the explainer on the question about what the Supreme Court has pronounced itself on the question of children born out of wedlock, whether they are entitled to inherit, whether they are entitled as an equal share to other children or the siblings. Under the Muslim law, family matters are normally dealt with in the Qadhi's court. But take it like this: the Qadhi's court only deals with matters of personal nature of two practicing Muslims, not children. The jurisdiction of matters children is domiciled in the Children's Court and in the High Court Family Division and the Court of Appeal at the Supreme Court. Under the Muslim law, the culture and religion of Muslim is to ensure chastity and honesty in a marriage. So any child must be born in a marriage. And those children not born in a marriage are called monaharamu. In English, it's bad, but it's called a bastard. But under the law, and this is the position the Supreme Court spelled out very clearly, Article 53 of the Constitution of Kenya that deals with the best interest of the children. In Article 260, a child is defined as any young person below the ages of 18. Article 53 provides that in all matters concerning children, the best interest of the child is paramount. It also provides that in Article 53, every child, whether born in wedlock or not born in wedlock, enjoys the protection of the child, of the father. It does not matter whether the father is a married husband or is not a married husband. And that is the basis why the Supreme Court pronounced that every child has a right to inherit. Article 45 that deals with family provides that the family is the cradle for national cohesion. And therefore, every child, whether born of a Muslim child or parent, whether born of a Christian lineage, will be entitled to inherit the property. The Constitution provides that no child should be discriminated based on creed or based on how that child was born. Every child shall be treated equally like any other child. And the best interest of the child is captured in the Children's Act, where the Children's Act provides that every child, whether of a Muslim, born in a marriage, born outside marriage, does not get discriminated. Then the question that everybody is asking, why did the Constitution, the Supreme Court, go that direction? The Supreme Court now has settled the principle that every child born is entitled to inheritance from the parents who gave birth to that child. When you look at the international law, the law on the best interest of the child is captured in the United Nations Convention for the Rights of the Child. This is a convention that now has been signed by every country in the world, including Somalia, that joined the other day. It provides the same principles of equality of children regardless of how they were born. coming to the African setup, the African Charter for the Welfare of the African Child, which is an African convention where all the 56 countries of Africa have signed and ratified the treaty. It makes it mandatory that states, those are countries, must protect children regardless of how those children were born. In the African Charter, there are children called taboo children, children born out of wedlock, children born in circumstances like that, children who are disabled, children who have come out of rape. All those children are protected by the law. Coming to Kenya, the Children's Act, plus its amendment, provides for the protection of children. Therefore, Honorable Duale, the Minister for Health, and very many Muslim leaders have come out to condemn the decision of the Supreme Court. Now, Court Helicopter has settled that. Court Helicopter has provided the international law. It has provided the constitutional provisions. It has provided the statutory provisions, and it has provided for cultural basis on which no child, whether born mwana haramu or a bastard, shall be discriminated, because that is the law as it is. The Muslim community, the Qadis, are bound by the decision of the Supreme Court. And because there is no appellate provision, that now becomes the Kenyan law, unless they can go to the East African Court of Justice, and the jurisdiction has been defined that once the Supreme Court has pronounced itself, that becomes finality, and therefore I am endorsing the position of the Supreme Court that no child should be discriminated by virtue of how the mother and father got that child, whether outside marriage or within marriage. And remember how many children are born of single mothers. How many children in this country don't have both parents appearing as parents. This is a landmark decision for the best interest of the Kenyan children. Thank you very much.